Carole Ann is the spokeswoman for the Lesbian Action Group. In September 24, LAG appealed a decision from the Australian Human Rights Commission denying them an exemption to publicise and run lesbian-only events. The results of that appeal came out last Monday. Carole will talk about the decision and its implications for lesbians and for women in general in Australia. We have the lovely Carole Ann. Carole, please go ahead.
Okay, here I am, and thank you for having me here. I'm spokesperson for the Lesbian Action Group. And on Monday, we had the decision come down from the Administrative Appeals Tribunal, now the Administrative Review Tribunal, undergone a change. And so I want to go through some of the stuff that was in that decision. I'm not a legal person, and it's a bit intimidating to know that there's Elizabeth and Anna and probably some others who are legal people who understand it a bit more. But I'm a lay person, and here's some of the things that I picked out from that decision. You can, if you haven't seen it, it's on our website with all the other bits and pieces about our case. So you can go to lesbianactiongroup.org.au and find our website and read the stuff for yourself if you haven't already done so. So the case itself was the Lesbian Action Group versus the Australian Human Rights Commission. And we applied to the AHRC for a temporary exemption under the Sex Discrimination Act to publicise and run events for lesbians only, and the exemption was refused. So in 2024, we appealed that decision at the Administrative Appeals Tribunal, and on Monday we found out that the decision was upheld, i.e. the exemption was refused again. And this is what member Stuart Fenwick said about in his decision making. In summary, the applicants identify as a discrete minority. So we lesbians are a discrete minority. And what I think he means by that is sex realist lesbians are a discrete minority within a group in the community that is already identified by their sex and sexual orientation. So we are afforded protection of the SDA. You wouldn't believe it from their decisions, but so they say. And we, LAG, seek to actively discriminate against another group, that's men who want to be lesbians. Anything in italics here is my is what I've inserted to do away with their gender speak, because their whole decision is coached in gender speak. And unless we undo that, excuse me, unless we undo that language and put the real language there, then it doesn't make sense. So we want to discriminate against men who want to be lesbians, who are identifiable by their gender identity. And Mr. Fenwick has determined that endorsing overt acts of discrimination cannot be the intended effect of the exemption power in the SDA. I don't know what the intended effect, in fact, is, because granting an exemption, by definition, means that you are exempt and you are allowed to discriminate. So, right off the bat, the logic doesn't make sense, in my layperson's opinion. So one of the things that was argued, and that we as TERFs are quite well aware of, is that sorry, here we go, is that the SDA and the AHRC are establishing a hierarchy, and that trans far outweighs sex and sexual orientation. So it was contended that the approach taken in the decision under review highlights the rights of the trans community. This was said to have the effect of creating a hierarchy of rights. LAG, accordingly, oppose a construction of the SDA that in any way imposes a hierarchy. It was contended that discrimination and equality are two sides of the same coin, but the granting of a temporary exemption permits discrimination. So they say, the AHRC, submitted that the SDA does not establish a hierarchy of rights holders, nor does it involve a balancing exercise between the rights of men who want to be women and lesbians. All persons are entitled to the protection under the legislation, and a decision to depart from the, and here I've underlined, norm sought to be established by the SDA is not unfettered. So this is their line, that they've established a norm, and we can't challenge that. So it's the AHRC and the SDA has established this norm where they say there is no hierarchy, but that we can't discriminate against gender identity, no matter what. Some of the reasoning they give, or I've said here, Stuart Fenwick gives, the problematic nature of this issue arises for the intersectional features of lesbian identity. Now, what are the intersectional features of lesbian identity? Lesbians are females who are attracted to other females. Where's any intersectional features there? Well, they come up with the intersectional features, which is the meaning the intersection of sexual identity and sexual orientation with that of people who want to be seen as the opposite sex, i.e. transgender persons. So this is some of the problematic nature of this issue. And the grant of an exemption would potentially demonstrate the redundancy of the protected gender characteristic. Yes, that's what we're after. This cannot be understood as consistent with the scope and purpose of the SDA. So they've made their rules and they're sticking to it. Stuart Fenwick does not consider the evidence and arguments raised to have made a substantive case that lesbians born female in particular experience substantive inequality compared to men who say they are lesbians. And he says, I must therefore proceed with the further application of the SDA. So you can see what we're up against. The Sex Discrimination Act is what we're bumping our heads against. They've made their rules and they're using that as reasons to discriminate against us. And he further says that he means by this, in the context of the present facts, that an exemption that actively creates or promotes discrimination that did not previously exist should not be permitted. So the fact that nobody has challenged so-called trans lesbians and made a precedent, then they can't permit it. So we need more challenges, girls. We need more challenges in the courts. The arguments for the exemption, and these are just some of them, that are put in the decision. If you want to know more, go to the website and read more of the submissions put in. So we reiterated our objection to 2 key points. That is, it was contended that the proposition that not inviting certain people, i.e. not inviting men who want to be lesbians to an event, creates a risk of harm to those men, should be rejected and is outrageous. So us saying that we wouldn't want men who want to be lesbians at an event, they said that that creates a risk of harm to those men, and we say bullshit, basically. It was further contended that the application, that's us, have advanced substantive evidence demonstrating the risk of harm to lesbians who challenge the trans rights agenda, which we did. We put up lots and lots of examples of from X and other places where it's quite obvious that it's violence and intimidation and harm meant to us. But apparently that wasn't enough. So we also confirmed that we don't consider a person who is born male can change their gender. And that was quite liberating to be able to say that in court, I must say, even though they didn't, apparently he doesn't believe me. In response to a follow-up question from myself, she confirmed the view that this is a statement of fact. Of course it is. She stated that she had not seen any convincing evidence to say people can change sex. Rather, it was a belief that people held. We also put Professor Sheila Jeffries was our expert witness. She states the facts that lesbian women women being lesbians was previously an uncontentious matter, but now needs to be expressed because the gender identity movement that the idea that human beings can change sex and that men, persons of the male sex, cannot only be women but lesbians. And Professor Jeffries was absolutely amazingly wonderful in her evidence that she gave. And it appeared that Stuart Fenwick was quite captured by her, but obviously not enough to change his mind. He also says some quite important evidence was advanced concerning the support provided by LAG to young women who are experiencing distress from their personal gender transition. Oh dear, but this, however, this itself does not necessarily present a compelling reason to discriminate against people who have experienced a different form of gender transition. So the fact that young women who are detransitioning or desisting need support, and LAG is giving them that support or opening up avenues whereby they can get that support, it's not a compelling reason to discriminate against those other lot who have their own form of transition troubles. The subject of public controversy and protest, captured by the concept of the trans exclusionary radical feminist, that's us TERFs. I understand the applicant's position to be that the material lodged and aspects of the evidence at the hearing demonstrate that feminists who challenge the currently accepted legal framework, that's us, recognising gender we're subject to severe criticism, and their safety may be at risk in public events. But while I have a substantial body of material indicating opposition, i.e. hate, violence, threats, to the broad stance of the applicants and those of a similar perspective with respect to the right of men who want to be women, I do not consider this to be of particular value in support of the request for an exemption. So here it is in black and white. It doesn't matter how much research and proof and, in your face stuff that we show them, they don't consider this to be of particular value. We get some arguments against the exemption. This was from the AHRC. The underlying premise of the application that a person's sex cannot be changed and that trans women, i.e. men, could neither be women nor lesbians is contrary to the clear intention of the 2013 amendments to the SDA. So here we go again, banging our heads against the SDA. The AHRC has determined that that's what the SDA stands for. With respect to the matter of the underlying policy behind the SDA, I, Member Fenwick, consider it would be perverse outcome to grant an exemption on the basis that the applicants consider the law to be inappropriate or based on unsubstantiated science or on other policy grounds that are no longer considered sustainable. So again, doesn't matter what evidence we put up, SDA all the time, banging our heads against it. I just have to put up Dr. Eleanor Jeffries' expert witness. This is just some of her statements that the tribunal allowed to stand. The AHRC presented her as their expert witness, and they allowed her to say this bullshit. In her written statement, Dr. Eleanor Jeffries sets out her qualifications and experience, which includes certain academic experience and the history of lesbian feminism. Now, if you read the transcript of the tribunal, that you'll know that that is rubbish. She has no experience whatsoever in terms of feminist. Her experience is in sex work and with Scarlet Women. So, and here's her theory of feminism. The interpretation of different strands within the movement are briefly, we've got option A, feminism, which promotes the belief that anti-lesbian tendencies are a function of patriarchy. Well, yes. And a smaller subset of which maintains a binary understanding of sex. So LAG and those lesbians who, those feminists, sorry, because this is not about lesbians, this is those feminists are a smaller subset of option A who maintain that binary understanding of sex. And then we've got option B, which is a capitalist theory that promotes marriage and board representation. And we've got option C that sees lesbophobia as a function of capitalism, whatever that means. She's made this up as a exploitation of feminism. And we are a minority within a minority. Further questions addressed Dr. Jeffries' views. I hope I'm not going over time here. She explicitly stood by her opinion that a subset of option A lesbian feminists hold views similar to those of Nazi fascists. She stated that she observed this and similar rallies internationally and noted the willingness of lesbian feminists, including Professor Sheila Jeffreys, to attend in the presence of Nazi fascists. Dr. Jeffreys described the similarity in views as being that fascism is totally fine with exclusion on the basis of difference. You can read more of Dr. Jeffreys' statements in the decision. Yes, but there clearly she calls us Nazi fascists, and that this subset, and that includes all of you, I must say, because I'm assuming you're all feminists, of the kind that doesn't believe that you can change sex. We have more in common with Nazi fascists than the other strands of lesbian feminists. Here's a little bit about temporary exemptions and the ludicrousness of even having that in the SDA, because apparently you can't apply it. So briefly, what this paragraph is saying, that if they gave us a temporary exemption, the problem is that anyone that was associated with us would not have a temporary exemption, and therefore they would be liable for complaints based on discrimination. So sorry, got dogs coming in and out and kids and whatever. So if we hired a venue, then that venue would be liable to litigation. If we hired caterers for something, then the caterers would be liable for litigation. So what's the point of offering an exemption then? According to Mr. Fenwick, an additional consideration raised in response is the impact of the grant of an exemption upon members of the excluded community, being men who want to be women. So we have to consider the impact of it. So what's the point, really? I mean, exemptions are there to be able to discriminate in certain circumstances. If you're going to have to worry about who you're discriminating against and the impact on them, then again, there's no point in even having it in the Act. Here's a doozy. While I do not consider the possibility of public protest to be a sound basis for refusal, the hearing revealed that there is no solution yet defined to ensuring the enforceability of an exemption. The nature of control concerning attendance has been reduced by the applicants to the level of non-invitation, in that we said, well, no, if we have an exemption, all we would do is say that this is for lesbians only, and we have an exemption to do that. And they say, well, you can't enforce that then. So he says this potentially renders an exemption moot. So the protesters, the violent men, the predators win, because we can't have an exemption because they would protest us. Okay, that's about the other entities as well, like venues and caterers, etc., etc. So finally, the evidence of the parties diverges to some extent about the nature and impact of socialisation of the lesbian community in general. And that's why we wanted the exemption, because the lesbian community in a big country like Australia is really, really isolated. Unless we can publicly be visible and publicise our events, how do we find each other? We're a minority, a small minority in a big country. We need to be able to publicly advertise. So that's why we were going for the exemption. And he says, I do not consider that the challenges made in cross-examination to Dr. Jeffries' expertise damage the value of her evidence overall. So he's believing Eleanor Jeffries. She's got a good point, he says. It appears to me to be of similar quality and relevance to that of Professor Jeffries, and, according to Dr. Jeffries, is indeed built upon the professor's own work. So, madness. She read Sheila Jeffries' book and agrees with Sheila Jeffries, but is put up against us. So, as noted above, I accepted a general proposition that the lesbian community experiences inequality. Yes, we do. I consider the more pertinent issue to be whether the evidence of the applicants is adequate to contribute to justification of the exemption. On balance, I do not consider there to be sufficiently persuasive evidence that any continuing social marginalisation of the lesbian community in public can contribute to justification of the exercise of the discretion in this case. So basically, it doesn't matter what evidence we put up, doesn't matter what we say, we're not going to get an exemption. So that's gone over time. I'm sorry. That's my my presentation. I know that most people probably haven't read the decision, so hopefully you've got a little taste of what was said. And any questions, ask in the Q&A afterwards. Thank you, everyone. Thanks, Janet.
Thanks so much, Carole. And a staggering decision. Like, it's one thing to say, well, the law says this, but there's also reality, and somehow we have to put reality back into the law. So thank you so much for championing the rights for lesbians and all women in the work that you're doing. Lesbians have long been the vanguard of the women's movement, so here you are. Thank you so much.